right direction, you must know the path that you need to follow. Being ready and having everything pre-planned will make your life successful. Profession is the professional development and career guidance unit of Pro Studies, which help you to explore the unexplored areas of profession and the world of work. And this not only function as a forum which makes you aware of different avenues of the profession, but also it aims to connect the student fraternity and the professional community to a single platform. And this will feature the eminent personalities who have excelled in their hides in law and other law related fields and careers. You will be able to enlighten yourself with all the expertise and experience while being at home. We strive for progress. You all are aware of the online study sessions, the Pro Studies mobile application, websites, and profession is a novel initiative, a vital opportunity for the entire law students fraternity. Especially in order to benefit the law students at large, we are proud to join hand with the lead generation of Faculty of Law, University of Colombo. Together, we bring you this wonderful experience to expand your horizons, widen your knowledge, and heighten your courage. So you have no fear to enter the profession. Awake the professional in you. Right, ladies and gentlemen, this is the seventh session of the online discussion and lecture series on professional development and career guidance, targeting law students, apprentices, and junior lawyers. And this is a joint collaboration of the Pro Studies of Sri Lanka Law College and the lead generation of Faculty of Law, University of Colombo. And we warmly welcome all the participants for this occasion. And we should remind that this online discussion will be lively transmitted from two Facebook pages from Pro Studies and Lead Generation. And here we do the discussion from the Zoom platform. So for today's topic, international trade law and chamber work in practice of commercial law, we've invited the most suitable person to discuss about the topics. So let me introduce our guest speaker today, a legal practitioner since 1991, more than 2 decades, specialized in commercial law with special emphasis in maritime law, multimodal transport law, international trade law, company law, intellectual property law, and arbitration and banking. So he's a master's of law degree holder specializing in international trade from the University of Colombo. And he has experience in international and local arbitrations as a counsel as well as an arbitrator. So let me introduce to you. We warmly welcome you, sir, Chandaka Jayasundere, President's Counsel.
Thank you, Charita.
Right. Okay.
Shall I start?
Thank you very much for joining with us today's session, sir, because of your busy life schedule and amidst all the challenges, you accepted our invitation to discuss about the international trade law and chamber work in the practice of commercial law. Right. For the moment, you have prepared a presentation with regard to international trade law as the first session of this session. So you can present your presentation and discuss about international trade law.
Okay, thank you, Charita, and thank you very much for that very generous introduction. I don't know whether I'm the best person to do this. There must be definitely more better persons to do this. Anyway, but I do admit that I can talk about international trade because I have more or less, for some reason or the other, specialized in international trade in my practice. So we are, as I discussed with Charita, we will do the first part of the presentation on international trade, introduction to international trade, and from there onwards we will proceed to that. I think would take about half an hour to 40 minutes. And then from there onwards, we'll take it to the general discussion on what is a chamber practice in commercial law, what entails chamber practice. And I must thank my good friend, Dr. Cabral, for putting me into this soup by trying to speak about chamber practice. But anyway, having said that, let's start with the I'll get into the presentation subsequently, but I would like to first commence the discussion or my presentation at the moment in as to what international trade is, and whether international trade as a subject is or as a career option within the sphere of law is attractive, whether it is attractive monetarily, and then I will move on to the presentation with regard to the actual breaking down international trade. Now, although there is a subject called international trade itself is a subject has several components. For example, I remember Dr. Cabral spoke intellectual property. Now, intellectual property is a subject in itself, but intellectual property is amalgamation. The sphere of intellectual property is an amalgamation of copyright, patents, in industrial designs, trademarks, and unfair competition, and so on and so forth. So in the same way, international trade is a subject that that has as its component several other fields of law. So when you're talking about international trade, the entire ambit of international trade is a vast area. Generally, people will specialize in one specific area of international trade. I will discuss the areas later, but we'll specialize in one specific international area of international law. But if the fact that you are doing internet or you're involved in international trade itself will entail that you need to know at least a fair knowledge, more than a normal person with a knowledge of all those other areas are. So it is to that extent a very complex subject. And the other aspect is that the bigger problem that we have, or anybody having in being interested and following a career in international trade law, is the fact that neither the law college or the law faculty teach international trade law as a standard subject. If I'm not mistaken, parts are in commercial, the subjects of commercial law, but international trade as a subject is never taught at any of the law schools. I am not 100% sure about the London LLB, but definitely Colombo, the law college does not have international trade as a standalone subject. I have been telling and I have been trying to get it as a subject to law college, but I think for your fortune and our misfortune, they don't think that international trade should be a standalone subject. It's part of commercial law. Be that as it may, when you go into the profession, also international trade is a fairly niche area and a specialized area, which if I take in general, say we have about, I think, 20,000 lawyers. The lawyers who are full-time involved in international trade will be less than 100, most probably around 50 to 60 who are involved in international trade, and lawyers who are involved in litigation in relation to international trade will be somewhere around 10 people. Okay, because it's a niche area, complex area, and also the fact that work that comes in international trade is not so regular. Okay, right. Having said that, of course, uh, that does not mean that international trade is not an attractive career path for a young lawyer to take, because as you might know, Colombo is, if I'm not mistaken, about the 23rd or 22nd or 23rd busiest port in the world, right? It has a throughput of about 8 million container TEUs a year. Also, Sri Lanka is an export or industrial export country or an export economy. We are about the third or fourth in tea. Somewhere quite high, I think second, third, or fourth in rubber, and diamonds also. We are quite high up there as to export of our. At the same time, as in there is a lot of imports also. So from time immemorial, Sri Lanka has been a trading hub or a trading nation, which is one of the very reasons that any person who is interested in going away from the standard paths of a legal profession might want to look at this area of the law. Okay, right. And then also there is also quite a good opportunity that will come up within the next couple of years if everything goes well, when the Colombo, the port city comes into operation, goes online, and there is going to be a Colombo Financial Center that will be set up in the line of the Dubai Financial Center. There's also discussions of starting and setting up in what we call an international commercial court, where the agree to proceed to have their litigation done in an international commercial court. That is a new area that has developed from about 2015. At the moment, as usual, Singapore is, as usual, way ahead of all of this. So Singapore has a very successful international commercial court. Dubai has a very successful international commercial court. So has Qatar, and that is in our region. China also has a national commercial court, which has its own problems, but mostly regard to disputes arising out of the Road and Belt or Belt and Road Initiative. So that is a new concept of or a new jurisdiction that has developed in respect of international litigation, which is called International Commercial Court. If you all are interested, read it up on, you find it on the net. That is a new area where lawyers now, for example, if you take Singapore as an example, the International Commercial Court in Singapore is set up as part of the Singapore High Court. The judges are judges from Singapore as well as judges from Australia, the UK, and Canada, and other nations. Parties who wish to have their litigation, have their disputes decided by a court of law, can opt to go into Singapore and have disputes litigated in Singapore. Okay, there are certain threshold issues that needs to be satisfied by the parties before invoking the jurisdiction, but generally that is how it is done. Charita, is my signal picking up, or is it okay?
No, sir. Everything is fine. We can hear
no problem?
You and see you.
All right. Okay. No, because I got okay. So no problem. Right. So then, so now in Dubai, the Dubai Commercial Court, International Commercial Court, deals with disputes companies that are operating a financial center. So in line with those and mimicking those, the port city will also have a collectional financial center, and there is in the pipeline a Colombo International Commercial Court to be set up, and also that be promoted again. Colombo will be promoted as a hub for arbitration within the South Asian region, a hub for commercial arbitration and commercial mediation. How far it will be successful or not, I don't know. I have tried this before and failed for whatever reasons, policy decisions, whatever. I don't want to go into those things. But we won't be able to be the hub for Asia because Singapore has now taken over that role, always been the hub for litigation and dispute resolution in the Southeast Asian and South Asian region. Dubai comes as close second. So we might be once again one of the smaller players in litigation. So there is a vast scope that will open up with the port city, and with the port city also people are, it is being promoted as a place to have regional headquarters, regional officers and regional branches of multinationals. That again will give hand scope for issues with and jobs in respect of international trade. So international trade in itself is not a subject that is unimportant, and it is a subject that continues to have scope for a person who is interested in the subject. Secondly, if you look at if you think that it is international trade, there's a lot of travel involved. There will be globe trotting and flying here and there. Even before that is international, doesn't work like that. The high flying corporate lawyers are mostly people who deal with corporate work. Not that it's an international trade, but international trade per se does not mean that you will be able to travel a lot. If at all, it will just traveling from Colombo to Singapore, Dubai, if at all. But international travel and globetrot is not necessarily a part of international trade, especially in Sri Lanka. There's more travel if you're interested in traveling in dispute resolution, arbitration, investment law, and corporate work has more travel opportunity in international trade. Having said that, international trade is also important and interesting because one aspect of international trade is that most of the time, 90% of the time, one party to the dispute or your work in relation to international trade is most probably a international party. So there is a lot of interaction with lawyers and clients outside Sri Lanka as well as people. Okay, so it's a complex subject, but it's a very interesting subject, and is a subject which has a lot of hope, especially being in a country which has as an essential part of its economy import and export trade or trade work. So having said that, with regard to litigation per se in international law, international trade law, there is not much litigation. There is more arbitration, other dispute resolution mechanisms in international trade rather than litigation. But litigation itself is a very attractive field, which ends normal recovery work, and specifically you have in international trade the concept of admiralty law, which is a niche area of law which deals with recovery of claims where claim involves a ship. That is a different area of law. It's a very complex area of law. Again, a part of international trade is a legal recovery process in international trade. So let me, with those introductory remarks, we start with the presentation, and that I'll just go through what international trade is, and then we have a discussion subsequent to the next presentation also. Okay, right. Okay, for your information, this is a picture of the port of Colombo, early 20th century. This is what Colombo looked then. Even then, Colombo was one of the busiest ports in Asia. It was way busier than Singapore. There was no port in Dubai or any of the Middle Eastern countries. I think after the Australian ports, Hong Kong, and the port of Aden in Yemen, Colombo was the busiest port in Asia. However, we have now dropped down to about the 22nd in the world, about the 10th in Asia. Be that as it, let's get on with the subject. Okay, so international trade, or now they also use the word trans-border trade law, trans-border law, that is a relationship with, or the law with regard to the relationship between parties in respect of a trade agreement or an agreement which involves two countries from different, two parties, different countries. Okay, right. So now this is what I say, that international trade per se has several components in it. Main subject called international trade. International trade is amalgamation of all these other sub areas. So the study or what international trade relationship of parties with regard to the contract of sale. So the basic contract in international trade is the contract of sale, where one person in one country will be purchasing goods from another person in another country. So it has to have an international component, or a component which has a where the goods will cross a border. That's why it's called trans-border. So the contract of sale necessarily have to entail the goods being transferred from one country to the other country. So both parties can be in the same country. Say, for example, the buyer and the seller can be in Sri Lanka, but if the goods are coming from out Sri Lanka, that is considered an international contract in relation to international trade. The parties to the contract, that is the buyer and seller, can be in two different countries. The goods might be in one country, the buyer will be in a second country, and the seller will be in a third country. Even in those circumstances, as long as there is an international component in the contract of sale, then it becomes a part of international trade. Okay, so the basic underlying basis of an international trade transaction is the contract of sale, that is the buying and selling of goods internationally. Then those goods that is purchased in a contract of sale has necessarily then to be transported from one country to the other country, or one port to the other port, or one airport to the other airport. So the second contract that becomes important in international trade after the contract of sale is the contract of carriage. That is how and under what circumstances, using what mode of transportation is the goods that are purchased in terms of a contract is to be transported. transport, right? Then the third one is, how do you pay for that? How do you are the subject matter of an agreement for subject matter of a international. So, for example, or I will come deal with them individually. The next aspect of the concept of agent and principal. Agent and principal arises because most instances the seller or the buyer is in another country. That seller or the buyer or the party to the contract of sale may be entered in the country of by an agent for and on behalf of the other party to the contract. Is in India, the buyer is in Sri Lanka. The seller might have an agent in Sri Lanka who will be dealing with the buyer in respect of the contract of sale. So what are the what are the particular agent? It is the relationship and the obligations and duties that arise in respect of the agent and his principal in the other country. So these four aspects are the main areas of transaction which relates to international trade. You need the contract of sale. In most instances, it is a contract of sale of goods. Now, again, you in these of sale or the underlying contract which gives rise to the international trade relationship might not be only in respect of goods, it might be in respect of services. Then the focus changes to a certain extent, but generally the international trade with the concept of a purchase and sale of goods. Okay, right. So let's go one by one. International sale of goods, that is a transaction where either two parties in two different countries or same country dealing with it enter into a transaction or a contract for the sale and purchase of goods, right? So the sale of an international sale can be defined as an agreement for the sale of goods from one country to the other. An agreement between parties irrespective of the location of goods. So for example, you might have two in Sri Lanka. The both parties, that is the buyer and the seller, will be Sri Lanka, but you might be selling goods that are somewhere else. So let's say, for example, the goods might be in China, and the buyer enters into a contract with a seller in Sri Lanka who will source goods and bring it from China and deliver it to Sri Lanka, into the buyer in Sri Lanka. The parties being in Sri Lanka doesn't make the transaction international, but the fact that the goods are coming from another country makes that transaction international. Okay. Then the second one is the agreement can be between, this is normally the normal manner that is used, and that is an agreement between parties who are in different countries entering into a contract for the sale of goods. Now, in those situations, it might be that buyer is in Sri Lanka, let's say India, but the goods are already in Sri Lanka for some other purpose, or already in Sri Lanka in stock or in a bond. And with the contract of sale, the goods will be delivered. There, the fact that the goods are in Sri Lanka already make it in transaction, international trade becomes operative, but international trade situation because the parties are in two different countries, right? In Sri Lanka, okay, the law that governs the sale of goods is the Sale of Goods Ordinance. I don't want details of it since we are just doing overview of what international is, right? Right. Then the next one is, so that is selling of the goods. Now we'll take as an example the let's say for an example we'll take this example right through our discussion. Let's take example of a sale, let's say 10,000 shirts by garment manufacturer in Sri Lanka to a seller in the United States. Now, when you take that transaction, both components of a contract of sale, which has an international, is satisfied because the seller, that is the Sri Lankan garment manufacturer, is in Sri Lanka. The buyer is in the United States. Are manufactured, dispatched from Sri Lanka for delivery and receipt by the buyer in the States. So the parties are in goods will be going from one country to another country and will be going like crossing borders. Okay, right. So in such a situation, transported from one country to the other, the second aspect of international trade. So you buy the goods let's say in Sri Lanka. How does that those go from Colombo or Sri Lanka, United States? That is done by way of transportation, which is dealt with in the world in several conventions that have been in force for a fairly long period of time. So, for example, the Hague and Hague-Visby rules, which have been there, the Hague rules have been there from the 1920s, and the Hague-Visby rules, which is a amendment or a development of the Hague rules, happened in 1960. Rules deals with the carry, that is carrying the cargo, your 10,000 shirts from Sri Lanka to the United States. Transportation, that means by using, okay, right. Then the Warsaw Convention, which I believe is from the 70s, is the convention that deals with the carriage of goods by air. It also deals with carriage of people also by air, but as far as this discussion is concerned, the Warsaw Convention deals with the carriage of goods by air. So when you export by air, the convention that applies for that carriage is the convention. When you ship goods by sea, the convention that applies is the Hague and Hague-Visby rules. Now, this convention, that is the CMR convention, is not applicable in Sri Lanka, especially because Sri Lanka is an island without any land borders with regard to the carriage of goods over roads, and is applicable in the European nations. Then there are certain regional conventions dealing with the carriage of goods over roads in respect of the South American region and some Asian regions. But Sri Lanka does not have an international convention which deals with carriage of goods over the roads. Simply our roads don't cross a border yet, right? When it crosses a border, maybe somewhere in the future, the convention might come into become applicable. Then the CIM convention, that is also applicable only to Europe, and I think it as an example of carriage of goods over rails in the region does not apply, but the CMR and CMI convention will become applicable and will that you will need to have some knowledge of those conventions, because your goods that are being shipped Sri Lanka to any other, say for example, any country in the European Union, if something happens to the vessel while it is being carried over the road or by rail, you will need to have some, at least a passing knowledge of those. Now, that is aspect that we call unimodal transportation and multimodal transportation, right? Now, this is a movement that happened after 1950, and generally it's a development that started the introduction of containers in internet. Now, unimodal is of transport for the entire carriage. Okay, so if you are, as we said earlier, using a ship to carry your cargo from Sri Lanka to the United States and you are not using any other thing, then you are using one mode of transportation called unimodal transportation. Okay. However, if you are using more than one mode of transportation, so for example, if you are using a ship, then you are using carriage, an aircraft to carry your cargo from Colombo to the ultimate in the United States. That is called a multimodal transportation transaction, which means you're using several modes of transportation. For unimodal is the law which relates to unimodal is what earlier, that is for each mode of transportation you have a convention. Okay, so you will have your carriage of goods by air, that is the Warsaw Convention. You will have the Hague Dispute Convention. The problem that we have faced for a time is that there is no single convention that has been introduced for or to stipulate what is the law in relation to multimodal transportation. So if there is no law which specifies what should be the law that should be used for a multi-transportation transaction, then there is an issue as to who is liable in a transportation where several modes of transportation is used. So for example, in this, if the goods, your 10,000 shirts are loaded onto a train in Sri Lanka, goes to the train to a ship to an aircraft, and then it's back to a train and a lorry before it is delivered. And at the time of delivery, the goods are damaged. Who is going? Is a unimodal transportation. If it is only a ship, you know, good like damaged goods are given to the ship in Colombo, damaged are delivered in, let's say, New York, then you know that the person is the guy who's operating the ship. But if you are using several transportation modes, then if you damages, who is the person who is liable, right? So as I said, your multimodal means goods are carried either in, goods are carried either in one mode of transport or in a combination of several. This is unimodal, then, okay, sorry, unimodal. Then containerization. Containerization issue. Containerization is a technical matter, that is a shipping or technical matter. Containerization doesn't change the law in any way, but it was because of containerization that it became very easy, different transport modes to carry the cargo, because you put it in one container and that container is never opened until, and each transport mode has special methods of carrying the container. So as you might have when you are driving in Colombo, container lorries are specially to carry containers, ships fitted to carry containers. Then rail carriages are also specially constructed and fitted to carry containers. So the same box will go from Colombo to New York in the United States in the same box without having to unloaded and loaded change of transportation. Okay, so right. So at present, 90% of the global trade by value and 50% of global trade by weight is transporting containers. Right, over 200 million containers are shipped every year. All right, right. Then this is the other part of it. The contract of carriage by sea is done by, I will just go through this without giving you, without going into too much details, is the contract of carriage by sea is normally evidenced by the bill of lading, and where that is with regard to carriage of goods in a normally operated ship. But if you require an entire ship to carry cargo, then that is done by what I call charter parties, which are hire agreements, hiring agreements. We will just, because we are running short of time, I will just jump that. Then, so that is with regard to contract of carriage by sea. You do it by a bill of exchange, bill of lading, or by chartering the entire ship. The contract of carriage by air is done by what is called airway bill. Okay, sorry, airway bill. And in Sri Lanka, in respect of carriage by sea, the act that applies is the Carriage of Goods by Sea Act of 1982. The contract of carriage by air is governed by the Air Navigation Special Provisions Act of 1978, if I'm not mistaken. So those are the different aspects of the carriage of goods from one destination to another. Okay. Now, one of the biggest problems that have now arisen is with regard to multimodal transportation, where, as I said earlier, if you can't pinpoint, ascertain where the damage happened, then how do you decide on the liability of the individual carrier? Okay, right. Then you come to the third aspect of international trade, that is method finance in international trade. Right? Sorry. So the payment clause in the contract of sale will have the time of payment, place of payment, mode of payment, and the currency of payment, right? Then internationally, although several modes of payment are used, all modes includes 4 essential elements, right? But I will not go into these things, go into details, because we are running out of, we are running quite tight on time, right? So you have what I call collection agreements, that is payment through banks. Then you have letters of credit transactions, where the payment is again made through the banking system in an international transaction. So in both collection agreements and letters of credit transactions, the money, the bank acts as a mediator or the middleman, and the money is paid by the bank only when the documentation in respect of the goods are received by the buyer. Otherwise, if there is no proof that the goods have been transported to the destination, then paying will be of no use, because the goods might never come. So the payment methods are specifically provided to cover a situation where the money to be paid to the seller is paid only upon a guarantee of the goods being received by the buyer. Okay, right. Then the fourth aspect is agents in international trade, where I explained this, where the agent represents a principal abroad, and then the aspects of liability in respect of that agent's conduct. So whether the agent becomes liable personally or the principal is liable for the acts of the agent will be decided in terms of the law of agency, right? So I won't go into through this. Then there's another new concept of what is called a freight forwarder, who is a person who will arrange for the carriage of goods from the port of from the place of loading to the place of discharge. The freight forwarder takes the entire responsibility of hiring the individual modes of transportation. Now that's a new concept, again started maybe somewhere in the 1980s to 1990s, and an area of lot of litigation and lot of disputes as to the liability of a freight forwarder in respect of transportation. So there is no specific law relating to freight forwarders, right? And the rights and liabilities are normally decided in terms of the normal law of contract. So, right? So, I'm sorry to rush through this, but the basic, as you might understand, as you go along talking about international trade, it becomes, now this is just an overall overview of what international trade is, but each aspect of international trade has career opportunities, especially in a country like Sri Lanka, which has export import trading as a cornerstone of its economy. So for example, with regard to contracts of sale, there are so many companies, big conglomerates which work with international trade. For example, if you look at with regard to companies or organizations which deal with the purchase of goods and goods in Sri Lanka, you're talking from any of the big companies like Haley's or Atkins Spence, the big tea companies, then Unilever. Also, see the government entities like Petroleum Corporation, Ceylon Electricity Board, the Satosa, Sri Lanka Board. So all those companies, all those organizations are involved in international trading. And when any company or any organization is involved in international trading, there are aspects of that international transaction where if you specialize in a particular area, you will be able to contribute to a bigger, higher extent than a normal lawyer would do. So then with regard to carriage of goods, you have so many freight forwarders. There are international shipping lines in Sri Lanka like Maersk and CMA. There are companies which run ships in Sri Lanka. Then you have freight forwarders, you have air cargo carriers in Sri Lanka. So in that, then with regard to payment, international trade payments are all done through banking, banks, and there are specialized areas in banking law in relation to letters of credit and collection agreements. So the scope of work that is involved in an international trade is an area that is very attractive, and where there are much more opportunities of obtaining work than, for example, let's say corporate work. Of course, company law and stuff, you normally, because of secretarial work and people, there are opportunities. But international trade, if you are specializing in international trade, definitely you have better options of joining the private than, for example, specializing in intellectual property. There is a bigger scope in international trade than I'm talking about Sri Lanka, than I think at the moment doing IT in Sri Lanka. The other thing is that's because you're more or less, if you're doing international trade, you're specializing in the laws which relate to international conventions, for example, the Warsaw Convention, or the with regard to carriage. Then the carriage of the sale of goods has on its own several conventions, including the Convention on International Sale of Goods, which Sri Lanka is not a part of. So because you are dealing with not only Sri Lankan law, but international conventions, and in most instances, the law that is applied is the English common law. In most instances, there are opportunities for you, if you have some experience in Sri Lanka with work in international trade, to find work generally or mostly in Dubai and Singapore, maybe Hong Kong, but mainly in Dubai and Singapore, because your experience in international convention work. So it's a lovely subject. And one other thing, this of course relates to any law that is outside law, or that is outside the mainstream law, like property persons, that kind of thing. These are niche areas, for example, intellectual property, Companies Act, international trade, carriage of goods, admiralty law. Those are things that unless you have unless you like that subject, it's very, very difficult to enjoy doing international trade. For example, for me personally, I have always liked transportation for whatever reason. I have always liked transportation, and I have always liked how goods, that is of course later on, but how goods and the liability arises, that really attracts my like intellectually, that is very attractive to me. But that now I don't have that much of interest or curiosity in respect of other aspects of even commercial law. Certain aspects I don't. So it's always better if you know, or if you like the kind of business, business that entails with international trade. It's always then the work becomes interesting. In the same way, if you like intellectual property, or if you like copyright, then it's always better to do something that you like. Okay, so that is generally what international trade is. You can definitely ask any question you want at the end of our second part, the lecture, presentation, and we'll have a chat afterwards.
Yes, certainly.
Okay,
And it was a wonderful presentation, and thank you very much for preparing such a thing on behalf of us for the benefit of the law students, apprentices, and junior lawyers who are joining with profession. Sir, now it's time to move to the second part of the discussion to discuss about the chamber work in practice of commercial law. Sir, yeah, as my first question, is there anything special with regard to the chamber work in commercial law? Like, how does it differ from other aspects?
Well, chamber work itself is, I personally don't think it differs from the area of law. Say, for example, chamber which deals with criminal law or criminal law practice, chamber which deals with, for example, property, it does differ in the context that the clientele is different. Okay, so when you're looking at commercial, say, okay, so you are looking at, let's say, within civil law, if you are looking at, let's say, property law, that is your standard partition, rental ejectment, that kind of work, the clientele generally will want the lawyer during the weekend because they are working elsewhere. Okay, so they might not be able to take leave and come and meet you during the week. So I have found that most chambers which has property as their main component, the amount of work that is done during the weekend is much more than like in the context of seeing clients and having consultations is much more than in what we do in commercial law. Because in commercial law, most of the time, our clients are people who are working in a corporate environment and in companies. They would rather prefer not to come for consultations and come and hang around lawyers' chambers during the weekend. They would rather work during the week or immediately after work, that is in the early evenings or so. So I have found that personally that people who are involved where the clients are personal clients, like it's like people centric, like your divorce work, your property work, your land work, then the more of the consultations are done during the weekend. So like, I know several of my friends who are leading practitioner chambers in property law. They work Sundays from 9 to 10, 11 in the night. Whereas for us, there are some commercial chambers also work like that, but I personally don't work during the weekend. That is some other aspect I will come to later. But the main difference between a commercial law chamber and even criminal law chambers also, that aspect is there, because the majority of work comes, that is consultations and stuff comes during the weekend. Okay. That is the main difference I can expect, because the work-wise, any part of the law, whether you are doing criminal law, property, personal laws, divorce, or commercial, the amount of work that you have to do doesn't change.
Right. So in the previous session with Dr. Cabral, we came to know that this field of law requires a great deal of research skills. So as a practitioner, a person having a much more experience, like more than 2 decades. So how can you comment on that? How can you elaborate on that thing?
The amount of research you need.
Yes.
Yeah. So generally, I personally, okay, let me answer it this way, right?
Mm-hmm.
If you are doing, I'll take only civil law, right?
Certainly.
If you are doing, say, property, litigation with regard to property, litigation with regard to personal, like divorce and testamentary, most of the law has been established for a long time. Okay. Most of the judgments and the seminal judgments have been there for 50, 60 years, right? But if you look at the commercial law part of it, commercial law, especially if you are looking at, say, for example, intellectual property, company law, if you are looking at international in the information technology, and you look at international trade also, the laws keep on evolving. I am not in any way taking away from the amount of research that you need for the other practices or other aspects of practicing. But as far as commercial law is concerned, the keep on changing, and you have to be up to date with the law. It's not the amount of research that you actually need, the amount of research you need to be up to date. That is very high in commercial law. Amount of research that you require is there, whether you are doing commercial law, whether you are doing property, even if you are doing criminal. We normally say that criminal lawyers need not do a lot of research. So even criminal law, any aspect of the law, you need a serious amount of research. And without research, you can't do law. Without studying, you can't do law. But the only difference I can see is that the concepts of law in commercial law, and especially even in dispute resolution, changes and evolves all the time. So you have to be very, very up to date with new concepts. You can say, for example, copyright, right? Now, copyright, if you are studying, if you are practicing copyright within the last, let's say, 5 years, right? Let's say from let's say 2000, we are talking about the last 15 years, right? From last 15 years in respect of copyright, we have the uh, we have YouTube, okay, we have Twitter, we have Instagram, now we have TikTok, then we have WhatsApp. Right? Now all those platforms have developed within the last 10 to 15 years. Now TikTok, I think, came only within the last 2 years or 3 years, 2 years, right? So every time such a platform comes up, then there is a development of law to meet whatever problems that you have. So the law developed in respect of copyright, online copyright, then with respect to music, the streaming of music, downloading music, pirated music, all that stuff was within the last 15 years. Actually, there was no law in respect of intellectual property relating to online music distribution 10 years ago. Okay, so you have to keep on developing. Then if you are involved and if you are interested in international trade or like say international payments, then for example the concept of currency Bitcoin as a currency, Bitcoin or this using blockchains and all this. So those are developments of the law on which developments in the area of business for which laws keep on coming. Okay, so for now you all must be knowing what blockchain technology is. Using blockchain, that's another whole 1.5 hour lecture if you're doing it, but for that there is a set of laws that keep on developing to deal with blockchain. Now in Sri Lanka also people use what are called cryptocurrencies, that is bitcoins and stuff like that, right? So if you are using cryptocurrencies in Sri Lanka, then if you are involved in finance, international finance in Sri Lanka, you need to know what bitcoins is, you need to know what cryptocurrencies is. And I was listening to the bar association seminars recently with some experts from England, and they were talking about cryptocurrency, and even they were surprised that Sri Lanka is right like about the between the 50th and the 60th by rank by usage of cryptocurrency, that is a bitcoins, right? So if you are involved in finance, international finance in Sri Lanka, and you don't know what bitcoins is, or you don't know what cryptocurrencies is, if you don't know what blockchain is, then you lose work, you lose your edge, because you need an edge when you're doing commercial work. Okay, so that is the kind of new, you have to keep on developing or reinventing yourself if you are doing commercial work. I think that is a difference between commercial law and the other practices.
Right. Certainly. And sir, after the apprenticeship period,
Yeah.
the law students can, they enroll as attorneys at law.
Yeah.
So once they enroll as attorneys at law, they can select a field according to their desire, according to their anything. Like, for example, a person is willing, a lawyer, a junior budding lawyer is willing to join this sector, like the commercial law. So what skills does he or she need to possess? Because you always say that there's something, there should be an eager, there should be something, a motivation, there should be a proper skill to manipulate in this field. So how can you elaborate on that, sir?
Right. As I said earlier, I personally believe that if you don't like what you're doing, then you should never do it. Merely because you get entry into a chamber which specializes in a particular field of law, but you are not interested in that field of law, you should not do it. Because ultimately you have to enjoy your life. You have to enjoy what you're doing. This is my personal view. I don't believe, because I personally hate property law. of property is as good as anybody who has not even as a layman, right? Yeah, it doesn't attract me. In the same way, I have personal reasons with regard to that. So when you do that, and I like the commercial factor or the nature of commercial transaction. So, and that makes it attractive for me to do that sort of work. So that is a personal matter. The other matter is that if you want to specialize in uh, commercial law, I personally believe that waiting until you take your oaths to uh, decide what you want to do, we started long time ago. Now I think your basic attraction, or where you want to go, I think you need to decide by your final year of law college, or at the time you join, you start your apprenticing, because it's very competitive now. It was competitive those days also. So for example, because I liked shipping law, I went to Mr. Kanageshwaran and joined his chamber, right? Dr. Cabral, if I'm not mistaken, liked intellectual property, so he also went to Dr. Kanageshwaran, right? So like that, if you are interested in a particular subject, and you feel that there is scope for you in that particular subject, then you have to now, not those days, but now I think you have to decide on what you need to do much earlier and start your process. Now, there is another aspect of law that you also should consider. Litigation is not law anymore, right? Those days, to be a lawyer means that you have to go to court. Now that is not, that is not everything. Going to court is not everything. The opportunities that you have outside the litigation sphere is much more than in litigation. So if you're doing litigation, you have to find a chamber in the area you like, and then you have to spend 10, or I would say you need 10 years of real drudgery, without money, without payment, to become a good lawyer, and where you start making good money only when you're around 10 years in practice, right? Now at, at this stage, unless your family is your parents can look after you, I don't think anybody can go on till 10 years, right? So there are much more opportunities than litigation for people, especially people who are interested in areas other than the standard property law, divorce law, and criminal law, right? So if you are interested in international trade, there are enough and more opportunities in the corporate sector to work for example, to work for trading companies, the buying and selling companies. You can trade, you can work with the shipping companies, you can work with banks. Now for that, most of those jobs, they might not require litigation experience. Okay, so if you are interested, of course, if you are interested in litigation, you can't be waiting until you take course to start commercial law. Litigation means from the first day of apprenticing, you have to be on the ball. Otherwise, you can't do litigation, right? But if you are not interested in litigation, but you are interested in a particular subject, then you don't need to actually you don't need to wait until you apprentice and take course. You can do your internship in like, say, if you're interested in IT, information technology, you can intern. Now everybody interns, so you can intern in a IT company. If you are interested in shipping, you can intern in a shipping company. You can, even during an apprentice period, you can come to an arrangement with your senior and do more work in the area you like. So that litigation and this whole focus of this, and I think the lawyers are also going on about 1,000 people coming a year. It's not an issue. 1,000 people can't litigate. Ultimately, litigation is a competitive field. If you're good, you survive. If you don't, you don't. So if you are interested, as an answer to your question, if you are interested in litigation of a particular subject, then find your senior at the time of apprenticing and then continue with him, because now the most of the chambers who are specialized in these laws, these special areas, are completely full, right? Otherwise, if you don't want litigation, from the days of your law college or law faculty and your apprenticeship, look at employment opportunities outside litigation. Okay.
Right. And that was a little bit with regard to the chamber work in the practice of commercial law. So we discussed with you, sir, the international trade law and the practice in commercial law. I think we have 20 more minutes.
Yeah.
So as we decided previously, we can open up the session for the participants to ask questions from you, sir.
Yeah, of course.
Certainly. I think if any participant is not benefiting with this language, they can ask either in Sinhala or in English, any language convenient.
Yes.
So, sir?
Yeah. Unfortunately, I can't answer in Tamil. It's unfortunate that I can't do it, but English or Sinhala, it doesn't matter.
Yeah, we can benefit the participants with both the Sinhala and English media. So this opportunity is for the participants. So you can ask any question from our guest speaker, President's Counsel, Mr. Chandaka Jayasundere, about international trade law or the chamber work with regard to the commercial law.
Can I ask a question now?
Yes, certainly, you can.
Yes. Sir, it's really an honor to listen to this session. We listened to Dr. Harsha Kabra's session as well. And in that, I asked him a question about doing an LL.M, and he recommended me to actually do an LL.M before I take oath if possible. So my question, sir, since you have done an LL.M in trade law and since you practice in commercial law as well, my question is, sir, is it wise to focus on a specific field when doing an LL.M, or to stick to a safer, more wider field, something like international business law when approaching the academics of law?
It is, of course, a choice, because so for example, now I did my master's, I think about 10 or 15 years into my practice, right? I got my master, about 10 or 15, but because by that time I knew exactly what I needed my master's for. It was not a standard thing that I wanted, and my master's actually was although I did it with a lot of other subjects at the law faculty, but my master's was actually on as I discussed and doing my presentation, liability, how you identify liability in multimodal transportation. Now that is a niche area of international trade, right? That is international trade, transportation, multimodal transportation, and liability, right? Now that I managed to do it because that was a problem that was cropping up in my work, right? Whereas if I did a master's immediately after passing out, I would most probably have done it in international commercial law, and it would have been transportation, because I like transportation, so it would have been carriage of goods or something like that. It's I don't know, I can't actually tell you which is better, but I personally think you gain more if you do your master's after knowing exactly what you want to do, because the other aspect is that when, as I told you earlier, getting into a chamber is very, very difficult. Now if you are interested in like these specialist subjects like in commercial law, getting into a chamber is very difficult. Then if you are doing a master's out of Sri Lanka, if you go out of Halsdorf, and if you are doing litigation, if you go out of Halsdorf for 1 year, you come back, you are starting from scratch, because clients don't wait until you go and do your master's and come. If you can afford and you have rich parents, you can immediately after qualification go and do your master's, do a generic master's and come. And then maybe if you feel that you need more stuff, you can do a additional master's or a PhD later on. But if you are doing a master's in Sri Lanka, it's a personal choice. It depends on what you want. If you want just a qualification and the 3 letters behind your name, go ahead. Do it before you start even. It doesn't really matter. But if you want something substantive out of it, which will actually help in your work, then I personally think that you should do it later on in practice. Because I don't think having a master's makes that much of a difference if you're doing litigation, and you can do enough masters if you go into employment or work in a firm also. You can do your masters part-time. No? So I personally would suggest to wait a couple of years and then do it, because then you know where you are going and your masters will help you. Is that okay?
Yes, thank you so much for your advice, sir.
Thank you. No worries.
Right. Any other participants willing to answer questions? We have more time. So you can ask any question with regard to today's topic from our guest speaker.
Can I just say one thing, especially with regard to because there are, I think, more than 50% of the people who take quotes now are female, right? So there are problems in, and I can see even here, I think it's almost 50-50 male and female, even in the participants. There are issues with regard to females working in chambers. One is with regard to the times that chambers use, because generally chamber work, because you do your court work, I'm talking about a litigation chamber, right? You do your court work in the morning, then start your chamber work again in the evening around 5 or 4:30 or 5. Then generally chamber work, if you are doing research and all that sort of thing, chamber work goes till 10:30, 11, and sometimes even later in some chambers, right? So given the cultural stuff in Sri Lanka, sometimes there is an issue for girls to be working that late. In sometimes, not all the time. Then there are also other issues of working during the weekend, and that is one issue with regard to chamber work. It depends now. Some of the chambers don't work like that. There are certain chambers who adhere to general working hours, like you go to court, come back straight to chambers, work and finish off around 6. Then there are some chambers now, for example, my chamber, I don't have every day, I don't have juniors coming to chambers. I don't have chambers if I don't have consultations. Mostly we work online. Even before this COVID thing, our work was always online. Drafting, discussions, everything was always online. Because that is how I do work, right? But there are certain chambers that really, like you're looking at 12 hours of work a day, 12 hours on Saturday, 12 hours on Sunday. Some chambers only don't work on an afternoon or evening in a week. So that has become an issue with regard to girls apprenticing and practicing doing chamber work. Okay, so that also has to be taken into consideration. Okay, that is because if you are interested in litigation and you are doing chamber work, right? That is one aspect that I thought that you all should be aware of, because if you are not there to work when your senior wants you, then it is a problem, right? Unless you have an understanding senior. Seniors also, if they want something done, they look up and whoever who is there will get the work, right? So those sort of issues are also there. You have to be careful in deciding how to do those things also, right? of course, the easy option and the other thing of working that is actually not chamber work, it's actually working in litigation, is that you're not, most of the chambers, you don't get paid a monthly allowance or anything. You get paid according to the work you do. And especially if you are working with the press council, you get a proportion of the press, like say it's on always 1/3 of your senior's fee. Sometimes it works good if you have a senior who charges a lot of money, then you basically earn 1/3. But some chambers, some seniors give a small allowance per month. So whereas if you get employment in whatever area you like, then you are ensured that the end of the month you get paid. Because I remember, like, now when we started, luckily my wife was working, so there were months where I didn't make even 1 rupee, right? So unless you have some backup like that, litigation for the first, of course, after you establish yourself and start making money, then of course sky is the limit, right? But as an alternative, if you go into employment or you go into a firm, you are ensured, you are, if you go into employment, private sector, you won't get home at 6 o'clock definitely. But most of the firms work to normal working hours, so it becomes that much easier and more structured, whereas a private practicing lawyer is not structured, the system is not structured at all. So it's sometimes it's very chaotic. Sometimes if you want a structured life, litigation might not be, or chamber work might not be what you actually require. Then also there are certain chambers where there are lawyers who do a little bit of litigation, but there's a lot of other work like agreements and corporate work. There are chambers like that where you go into court. Now, I am a litigator. I have very little other work. My main focus is litigations. So for me now, for these days, without court, basically I have no work. No work means I have drafting and other things, but generally 80% of my time is taken in litigation. So there are some seniors who litigation part where you go to court is about 20% of their practice. For me, it's about 85, almost 85 to 90% is litigation, arbitration, and all this. So those chambers, your work is more drafting agreements, corporate works, company secretarial work. So that kind of chambers, you will have a more structured 9 to 5 kind of situation where most of the time you will get paid a monthly salary or allowance. But if you are looking at pure litigation chambers, then life is tough and it's very hard. But ultimately, I think it pays ultimately, like after 10-15 years, it pays much more, because if you reach the top half of your profession by the time you're 15, you're made financially as well as otherwise. Okay.
Right. That was a little bit of the experience that our guest speakers get, and a little bit of advice and a brief explanation about the current situation with regard to the chamber practice. So hope you all were benefiting with these ideas and the expertise that our guest speaker have gained. Right. We have a few more minutes. Any participants to ask any question with regard to today's session?
Excuse me, sir.
Yeah.
Thank you very much for today's insights. I'm a first generation lawyer. Do you have any other advice you could perhaps give me?
For first generation lawyers, doesn't make any difference at all. I am actually being first generation doesn't. Sometimes it's better if you have your father in the profession or something. But I am like I am like third or fourth generation. Doesn't make any difference if you don't make your mark by yourself. Whether you're fourth generation or 10th generation or first generation, doesn't matter. If It's what you do by yourself that really matters. For example, some of the best lawyers who are even presently there are first generation lawyers. You don't need connections, and unless because there's no, maybe to some at one point, or maybe that sometimes you will be, because you will be working with people who you know because your father used to, they are your father's friends and all that. That is just, that's about it. But it's not other lawyers who send you work, it's clients who send you work. So whether you're fourth generation lawyer and you go and mess up in court, you will not get work, right? And I don't know why it is so that it's only this legal field that it's with, whether you're third generation or fourth generation or first generation applies. Any other field, whether your great grandfather was a doctor or not, doesn't matter for in the medical field. It doesn't matter whether your father was chairman or John Keels in the private sector. So it's something that I don't believe in. If you're good enough by yourself, you don't need the shadow of your parents or your grandfather or your great grandfather or great uncle to hold your hand. Advantages maybe because you grow up in a environment where law will be discussed, and you are used to seeing law books and all that. Now, for example, in our family, my wife and I are both lawyers. So then it's some sort of an advantage, but otherwise, because then you're familiar with what people are talking about. But other than that, being a first generation lawyer has no problem at all. You just buck up and do your stuff.
Thank you, sir. One more question, if I may. So
certainly you can ask.
Yeah. So what do you look for in when you try to hire a junior or an apprentice?
Number one, I don't hire juniors; they come to me. I don't basically. I actually don't seriously look at anything if they are. I don't look at CVs. If they want to come and work with me, they can come and work with me. I have no problem like that. But the problem remains in that all the chambers in commercial law are chock-a-block with juniors. So getting into a chamber is going to be, it's difficult now. It's going to be more difficult as you go along. That is the only disadvantage that I can see, because very few senior lawyers are there who do commercial work, and most of those seniors have taken like enough and more juniors. I personally don't look at qualifications. I don't look at who normally everybody gets introduced by somebody. But recently also I took a junior who just called me and asked whether she can work with me. But the problem remains that there are very few places you will be able to get in. And it all, I don't think any of the seniors look at qualifications or CVs or anything when they take. Most of the time you are interviewed by somebody. If not, very few people I know will want you to see your CV or. But I think getting into a chamber while apprenticing is the secret, because apprentices everybody takes just tag along. But if you're and you learn fast, and because we can see people who are interested, we can see the difference between an uninterested junior and an interested junior. So you might have chances, but I personally don't look at any qualifications or anything. As long as you're you have passed your law finals, I'm okay. And I think that is the case in most of the chambers. It's just that there's a limit that seniors take now.
Thank you, sir.
Thank you.
Right. There were a few questions posed. So any more questions? So we can give few more minutes. The silence seems that there are no more questions. And sir, I think the time is also up. This was the 7th session of the pro studies, the profession, with the lead generation of Faculty of Law, University of Colombo, and Sri Lanka Law College, the pro studies team. We featured eminent personalities with eminent lawyers and the personalities with other law-related careers. And today we spoke about the international trade law and chamber practice with regard to the commercial law. So thank you very much, sir, for joining with us today amidst a huge workload. Mr. Chandaka Jayasundere, President's Counsel. Sir, as a final words, do you have anything to say?
Thank you very much. Thank you very much for giving me this opportunity, and wish you all the best, and that you are successful in your legal career. Thank you.
Right. Okay. Thank you very much, sir. Thank you very much once again for the participants as well for joining with Profession, Pro Studies and Lead Generation, a collaborative effort of Sri Lanka Law College and Faculty of Law, University of Colombo. So today we discussed a very important topic, international trade law, and we had a discussion about chamber work in the practice of commercial law with President's Counsel, Mr. Chandaka Jayasundere, an eminent personality in the field of law and a good practitioner and a person who is the most one of the most suitable persons to get advisors for law students, apprentices, and even budding lawyers. So thank you very much once again. So hope to see you soon with another session. Awake the professional in you.